very good evening to all of you friends. BYJU'S Exam Prep brings to you the weekly legal current affairs. Now, in this session, we bring to you those important legal developments that a student who is preparing for CLAT and other law entrance examination for the year 2024 should and must know. Now, over the last 5 years of CLAT that we have seen, since 2020 rather, since 2020, the kind of questions that have been asked in CLAT and other law entrance examination revolve around current legal affairs. So if you are one of those who is really aspiring to get into the top law schools of the country, this session will be of great importance because we shall be bringing to you the most important legal developments that have taken place in the last couple of days. So guys, let's begin with this session. But before I begin, BYJU'S Exam Prep brings to you a free workshop on time management tips for CLAT and boards. This free workshop is going to be conducted on 12th of February or at 7 p.m. So hurry up and register now for the free workshop on time management tips for CLAT and boards. This workshop will be conducted by Abhimanyu Sir. Let's come to the important legal development. Just because an appeal is filed, does it mean that the order against which that appeal is filed is stayed? No. The Supreme Court has clarified that filing of an appeal does not mean stay of the order which has been appealed against. Now, suppose the High Court has passed a judgment, has given a judgment. Now, suppose you are not happy with the judgment, you have a right to file an appeal before the Supreme Court of India. Now, just because you have filed an appeal before the Supreme Court of India, does it mean that the High Court's judgment has been stayed? No, it is not. Unless and until there is an order by the Supreme Court staying the operation of that judgment. So unless and until the Supreme Court categorically specifies that the High Court order is to be stayed, there is no such stay. So just because आपने एक हाई कोर्ट के जजमेंट के अगेंस्ट में आपने सुप्रीम कोर्ट में अपील किया, इसका मतलब ये नहीं कि हाई कोर्ट का जजमेंट का ऑपरेशन रद्द हो जाता है, unless and until the Supreme Court gives a stay order. Unless the appeal is listed and there is an interim order, mere filing of an appeal would not operate as a stay. That is what the Supreme Court said. Now, what is an appeal? You resort to a higher court to review the decision of a lower court. Suppose you go to a higher court. Now, against an order of a district judge, you go to the High Court. Against an order of a High Court, you go before the Supreme Court. So that is called appeal. Appeal simply means you are asking the higher court in the hierarchy of courts to review the decision of the lower court. Now, you can ask the higher court to reserve the decision or reverse the decision of the lower court which the lower court has given. So that is your prayer in appeal. I hope you guys are understanding. Now, moving on to the next important news. Right of unmarried daughter to claim maintenance. The Kerala High Court said. Now, what was the question before the High Court? The question before the High Court was whether a daughter who, although had attained majority but is unmarried, can she claim maintenance from her father? although she is not suffering from any physical or mental abnormality. The question over here is whether a daughter who has attained majority 18 plus, she is unmarried, can she claim maintenance from her father, or even if she is not suffering from any mental or physical incapacity or abnormality. Now, section 125 of CRPC says it provides for maintenance to the wife, child, parents. The court may order the husband to maintain the wife who is unable to maintain herself by providing monthly maintenance to her. That is the ambit of section 125. Section 125 of CRPC very categorically states that the husband can be asked to pay some money in case the wife is unable to maintain herself. Some monthly allowance can be provided by an order of the court. Now, insofar as unmarried daughter is concerned, now we are talking about an unmarried daughter, a daughter who has attained the age of majority 18 plus. She is not suffering from any physical or mental abnormality. Can she claim maintenance? Let's see what the court has said. An unmarried daughter who attained majority could not claim maintenance in ordinary circumstances, merely on the ground that she does not have means for her subsistence. At the same time, even though the unmarried daughter who has attained majority is entitled for maintenance, provided she is suffering from any physical or mental abnormality. If she is, where the daughter is by reason of any physical or mental abnormality, she is unable to maintain herself, she can claim maintenance from the father. So, an unmarried daughter can claim maintenance even if she is major, provided she is suffering from some kind of physical and mental abnormality and is unable to maintain herself. Very important. Very, very landmark judgment. Okay? Sorry. Is that clear? Every one of you? Any doubts? Any doubts that you guys have? Any doubts that you guys have, guys? Any doubts that you have? Is that clear? Any doubts? Okay. Moving on to the next important legal development. Justice Rohinton Nariman was addressing the 7th Chief Justice MC Chagla Memorial Lecture in Mumbai. So Justice Rohinton Nariman, the former judge of the Supreme Court, was delivering the 7th Chief Justice MC Chagla Memorial Lecture. And what did he say? He said that in the recent past, we have seen a huge amount of deliberations or debates relating to the process of appointment of High Court and Supreme Court judges. The law minister of the country, Shri Kiran Rijiju, in the recent past the law minister has questioned the collegium system of appointment of judges to the higher judiciary, that is High Courts and Supreme Courts. Now, during the MC Chagla Memorial Lecture, which was delivered by Justice Rohinton Nariman, he says the lecture was on the topic A Tale of Two Constitutions, India and United States, the long and short of it all. Justice Nariman says, if you don't have independence and fearless judges, say goodbye. This is nothing left. As a matter of fact, according to me, if finally this bastion fails, we were to fall, we will enter an abyss of a new dark age That is what Justice Rohinton Nariman says. Now, over the last couple of months, what we have seen is that the Law Minister, the Honorable Vice President of India, has repeatedly questioned both the basic structure doctrine as well as the appointment of judges that is done by collegium system. Now, the collegium system was formed by way of a judgment of the Supreme Court. Of course, the Constitution does not talk about the collegium system, but it was evolved. This process has evolved by a judgment of the court. Now, you might like a judgment, you might not like a judgment. But at the same point in time, we must remember that in our country, we have to respect the courts. Now, you might like a judgment, you might not like a judgment. You might be very critical of a judgment, fair thought. But does it mean that you can disobey that judgment? The answer is no. And that is what Justice Nariman was precisely hinting at. Justice Nariman said that there are two basic constitutional fundamentals. A minimum of 5 unelected judges are trusted with the interpretation of the Constitution. Once those 5 or more have interpreted the Constitution, it is your bounden duty as an authority under Article 144 to follow the judgment. More from Justice Nariman. You may criticize it. As a citizen, I may criticize it. No problem. But never forget, unlike me, you who am a citizen today, you are an authority. And as an authority, you are bound by that judgment, right or wrong. So Justice Rohinton Nariman very categorically states that the government might have its own reservation about the rightfulness or wrongfulness of a particular judgment, be that as it may. But as an authority of the country, you have to follow the judgment, and the judgment talks about the collegium system of appointment of judges. Okay, now the collegium system of appointment of judges deals with the fact that judges of the High Court and Supreme Court are selected, are recommended by the collegium. Now the collegium consists of the Chief Justice and 2 other judges insofar as High Court is concerned, and insofar as Supreme Court is concerned, it consists of Chief Justice and 4 senior most puisne judges. Now, insofar as the Constitution of India is concerned, the Constitution of India says that judges will be elected, will be made by the President. Okay, the President shall appoint judges of the High Court and Supreme Court. Now, by virtue of the various judgment, the second judge's case and the third judge's case, we got to have this collegium system. And that is the method of appointment of judges today. Moving on. Criticizing the union government for sitting over recommendation made by the Supreme Court, Justice Nariman said the government sitting on recommendation by the collegium was deadly against democracy. So the former judge of the Supreme Court, Justice Nariman, was actually criticizing the fact that of late the union government is sitting on files insofar as recommendation of judges to the High Court and the Supreme Court is concerned. In the reply to the comment made by the Vice President of India that the basic structure doctrine is expedited by the Supreme Court in Keshwananda Bharati hinders the functioning of the Parliament. Now, just a couple of days back, the Honorable Vice President of India, Shri Jagdeep Dhankar, made certain comments relating to the basic structure doctrine, which was expounded by the Supreme Court in Keshwananda Bharati's case. Shri Dhankar, the Honorable Vice President, said that the basic structure doctrine hinders the functioning of the Parliament. To this, Justice Rohinton Nariman replied that so, Let us remember when we speak about the basic structure doctrine. That is a doctrine that has been used by minority judges first. It is a doctrine that was sought to be undone twice, and that was sought to be done over the last 40 years. So let us be clear that this is something that has come to stay. And speaking for myself, thank God it is. So there were a lot of criticism by the politicians, by the executive relating to the basic structure doctrine, specifically insofar as the NJAC judgment is concerned. And what is this NJAC judgment? This NJAC judgment deals with the fact that a method which was laid down by the parliament of appointment of judges to the higher judiciary, High Court and Supreme Court, was struck down by a 4:1 majority. Now, after that, there has been a number of confrontation between the government and the courts insofar as appointment of judges is concerned. Is that clear, everyone? Is that clear to each and every one of you? Am I clear? Am I clear to each and every one of you? Okay? Okay. BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course. We provide you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law entrance examination, a monthly e-magazine for current affairs, and the entire content is based on the extensive analysis of the last 5 years of CLAT question paper. Moving on. The Supreme Court has clarified its judgment decriminalizing adultery. A 5-judge constitution bench comprising of Justice K.M. Joseph, Ajay Rastogi, Aniruddha Bose, Rishikesh Roy, and Justice C.T. Ravikumar held that the 2018 judgment of Joseph Shine, the 2018 judgment of Joseph Shine will not impact court-martial proceedings. Now, in the Indian Armed Forces, adultery has been decriminalized. But that does not mean, the Supreme Court says that does not mean that court-martial proceedings under the Armed Forces Act, they can be stalled. No. Armed Forces personnel will be liable to face disciplinary action for adultery. That is what the Supreme Court has said. That this judgment, the Joseph Shine judgment, will not impact court-martial proceedings insofar as armed forces personnel are concerned for conducting an adulterous conduct. The Supreme Court said that persons subjected to the Navy Act, Army Act, and the Air Force Act by virtue of Article 33 of the Constitution being a distinct class, any promises or adulterous act by such person shall be allowed to be governed by the relevant provision. So, in the army, if an army personnel gets into an adulterous act, he can be subjected to certain disciplinary proceeding. The Army Act, Navy Act, and Air Force Act are self-contained code. It is the form of self-regulation where only armed forces can fully appreciate and understand what can lead a trigger, which can be a breach of military discipline and impact security. So, the Supreme Court said that the Joseph Shine judgment, which decriminalized adultery, does not mean to say that people in the army, people who are working in the army, the Navy, and the Air Force will not be subjected to disciplinary proceeding if they enter an adulterous relationship. Moving on to the next important question. Former Law Minister Shri Shanti Bhushan has passed away. Who is this former Law Minister Shanti Bhushan. He is the father of the present Prashant Bhushan, who files a lot of cases in the Supreme Court and is a very senior lawyer. Now let's understand certain important facets about Shanti Bhushan, the great legendary lawyer Shanti Bhushan. He represented Raj Narayan in the legendary case in Allahabad High Court, which resulted in unseating of Indira Gandhi as Prime Minister in 1974. So, late Sri Shanti Bhushan appeared for Raj Narayan against Srimati Indira Gandhi before the Allahabad High Court, which unseated Prime Minister Indira Gandhi in 1974. Sri Shanti Bhushan also served as the Law Minister of India between 1977 and 79 under the Morarji Desai government. He also argued ADM Jabalpur case during emergency. What was the judgment of ADM Jabalpur? Sri Shanti Bhushan argued that even during emergency, citizens have right to life and personal liberty. Of course, Article 19 and Article 21 are those inseparable rights which still can be found with every citizen during emergency. But it was not accepted. Later on, of course, in Puttaswamy, ADM Jabalpur was overruled. He was also responsible for drafting and piloting the 44th Constitutional Amendment, which undid what was done during by the 42nd Constitutional Amendment during emergency. So during emergency, the Indira Gandhi government brought in the 42nd Constitutional Amendment. Sri Shanti Bhushan was the man who was responsible for drafting the 44th Constitutional Amendment, which changed what was changed by the 42nd Amendment. So what was done by the 42nd Amendment had to be undone, and that was done by the 44th Constitutional Amendment. Okay. Moving on. BYJU'S Exam Prep brings to you a free workshop on time management tips for CLAT and boards. This free workshop is going to be conducted on 12th of Feb at 7 p.m. So hurry up and register now for the free workshop on time management tips for CLAT and boards. This particular workshop will be conducted by Abhimanyu Sir. Moving on. The Supreme Court has issued certain guidelines relating to under trial prisoners on account of inability to fulfill bail condition. Now, when a person is accused of a particular crime, he can be arrested, and later on, under the criminal procedure, we see that there is a provision of bail. Now, what is this bail? Bail is granted by the courts to people who are facing some kind of criminal charges. Now, there are certain conditions. The courts might say, okay, you pay 50,000 rupees as bond, 1 lakh rupees as bond. Now, poor people in the country are unable to pay, and for that reason, they are languishing in jail. The Supreme Court said that the court which grants bail to an under trial would be required to send a soft copy of the bail order by email to the prisoner through the jail superintendent on the same day or the next day. The jail superintendent would be required to enter the date of grant of bail in the e-prison software or any other software which is used by the prison department. Furthermore, the Supreme Court said that if the accused is not released within 7 days from the date of grant of bail, it would be the duty of the Superintendent of Police to inform Secretary DLSA, that is, District Legal Services Authority, who may depute paralegal volunteers or jail visiting advocate to interact with the prisoner and assist the prisoner in all ways possible for his release. Now, You have been granted bail, but because you are unable to satisfy the conditions of bail, you are languishing in the jails. And the Supreme Court says that this is a very sorry situation. The Supreme Court has also said that NIC would make attempts to create necessary fields in e-prison software so that the date of grant of bail and the date of release are entered by the prison department. And in case the prisoner is not released within 7 days, then an automatic email can be sent to DLSA, District Legal Services Authority Secretary. So, if a person who has been granted bail is unable to fulfill the terms and condition of the bail, and they are languishing in bail, in those conditions, what should the courts do? The DLSA, the District Legal Services Authority, with a view to find the economic conditions of the accused, may take help of the probation officers and paralegal volunteers to prepare a report on socio-economic condition of the inmates, which may be placed before the concerned court with a request to relax the condition. In case where the under trial or convict requests that he can furnish bail bond or surety once released, then in an appropriate case, the court may consider granting temporary bail for a specified period to the accused so that he can furnish bail bonds or securities. Is that clear? So, to produce bail bonds or sureties, he can be granted some time. Am I clear? Each and every one of you. ठीक है? सभी को समझ में आ रहा है? Okay. Further, it was held that if the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case and consider whether the conditions of bail require modifications or relaxations. So, if a court has granted bail to an individual on a date, and 30 days has passed, that is 1 month has passed, and still he is languishing in jail, the court can suo motu take up those issues and see whether they can relax certain conditions of the bail. Furthermore, the court said that one of the reasons which delays the release of the accused convicts is insistence on local surety. It is suggested that in such cases, the court may not impose the condition of local surety. So these are certain guidelines that has been issued by the Supreme Court insofar as dealing with those people who have been granted bail but cannot come out of the prison owing to the fact that they do not have resources to fulfill the conditions for grant of bail. Moving on, the Supreme Court has recommended Justice Rajesh Bindal and Justice Arvind Kumar as judges of the Supreme Court. The Supreme Court of India has a sanctioned strength of 34 judges, but presently there are 27. So, around 5 judges have been appointed, I think 2 days back. They have been given the oath, and I think today evening, the law minister has confirmed that Justice Rajesh Bindal and Justice Arvind Kumar the government has finally recommended their name for judgeship. On 13th of December 2022, the Collegium of the Supreme Court appointed 5 names for appointment of judges to the Supreme Court. They were Justice Pankaj Mittal, Justice Sanjay Karol, Justice P.V. Sanjay Kumar, Justice Asamuddin Amanullah, Justice Manoj Mishra. So they have been recommended, these 5 judges across the country were recommended to become judges of the Supreme Court by a recommendation of the Collegium on 13th December 2022. But they were never been notified till that time. The collegium further recommends that Justice Rajesh Bindal and Justice Arvind Kumar be appointed judges of the Supreme Court of India. So along with the 5 judges, the Supreme Court said additionally 2 more judges will be appointed. Now this is a very important clarification. The Supreme Court for the first time said that the names recommended earlier by the collegium by its resolution dated 13/12/2022 shall have precedence over the 2 names recommended presently for appointment to the Supreme Court. That means the December 13th recommendation of 5 judges will have precedence. They should be appointed as judges first, and only after that the new 2 judges, Justice Rajesh Bindal and Justice Arvind Kumar, will be appointed thereafter. Therefore, the appointment of 5 judges recommended on 13th December 2022 should be notified separately and earlier in point of time before the 2 judges recommended by this resolution. So before Justice Rajesh Bindal and Justice Arvind Kumar is appointed as judges of the Supreme Court, the earlier resolution which recommended 5 other judges should be notified prior to that. Right? Did you all understand, all of you? Are you enjoying? Tell me that. If you are enjoying this session, do press the like button. If you are enjoying this session, do press the like button, guys. Okay. Moving on. The central government on 4/2/2023, just 6 days back, has notified the appointment of 5 judges to the Supreme Court. Who are they? Justice Pankaj Mittal. He was currently the Chief Justice of Rajasthan High Court. Justice Sanjay Karol, who was the Chief Justice of Patna High Court. Justice P.V. Sanjay Kumar, who was the Chief Justice of Manipur High Court. Justice Asamuddin Amanullah, who is a judge of the Patna High Court. And Justice Manoj Mishra, a judge of the Allahabad High Court. So these 5 has already been appointed as judges of the Supreme Court. Very soon we will see Justice Rajesh Bindal and Justice Arvind Kumar in the Supreme Court, which means 34 judges in the Supreme Court within a very short period of time. So guys, BYJU'S Exam Prep brings to you CLAT 2024 Comprehensive Course. Secure a seat at your dream NLU. We shall be providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exam with video solutions, monthly e-magazine for current affairs, and the entire content is based on an extensive analysis of the last 5 years of CLAT question paper. So get your ticket to your dream law school by joining CLAT 2024 Comprehensive Course by BYJU'S Exam Prep. So with this, guys, we come to the end. Do subscribe to our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S Exam Prep app today. With this, we come to the end of this session. Thank you very much. God bless you. Have a great weekend ahead. Bye-bye. Take care. Ta-da. Thank you. Bye-bye.